And the next case on the docket is Palmer versus Palmer, case number 2025-0118. And as soon as the attorneys in this previous case have cleared, the attorneys are welcome to take their positions.
Appreciate it. I got it. Thank you.
What do you get for presiding? Like $10 for presiding?
How much hazard pay?
Certainly free with your compliments.
An extra box of pens.
So I'm gonna get some great questions from my colleagues here today.
Always stellar.
It's your turn to get it right. Brian and I both got it right last time.
Okay, yes. This is Marat.
Good morning. May it please the court, Allison Marat for the appellant Toby Palmer. I would like to reserve 5 minutes for rebuttal.
Okay.
As the court knows, this is an appeal about a fire department pension and a marital settlement agreement. We recognize that this is a contract case, and because of that, the traditional rules of contractual interpretation apply. And that's where I'd like to start today. Importantly, there is a rule known as the presumption of incorporation. Contracts are made with the law in mind. There is a presumption that the existing law is incorporated into the contract. And here, Florida black letter law says that pension money earned after a divorce is not marital property or subject to equitable distribution. Now, we acknowledge that there is freedom of contract. However, the freedom to contract is not a free-floating event that's untethered to the law. If the parties want to depart from the law, they have to clearly say so. Otherwise, silence, vagueness, or ambiguity means that Florida law controls. Even if the agreement doesn't expressly say so, the provisions of Florida law are incorporated into the contract.
Okay, so if I'm gleaning from what you're arguing, so the part of the ex-husband or former husband's pension post-divorce is a non-marital asset.
Yes, Your Honor.
So, and then you talk about freedom of contract. I mean, so if I inherit money from my mother's estate and my wife and I get divorced, I can contract to give her a portion of that estate monies that I received from my mother, even though she would not otherwise get it through a trial, right?
Correct, Your Honor.
Okay, and so your client had the ability to say, okay, I have this pension, it's a marital asset, and I think the number that everybody's landing on, it was $84,000 marital asset, but he can agree to pay 40% of whatever it is that's the non-marital asset, over and above the 40% of the marital asset, come retirement time, or at the time of his death, I guess it would be 50% if he predeceased. I mean, he's able to do that, and so isn't the question then whether the verbiage of the agreement that he signed that was incorporated into the final judgment isn't that what happened?
That's the precise...
I know he says no, that's not what we meant,
Right.
And let me maybe jump ahead, and I apologize for compounding my questions. Maybe Judge Wallace will object to my questions. But didn't the trial judge hear, quote, parole evidence about what the parties intended to, whether the trial judge intended to or not? But didn't your client put on, well, that's not what we meant, and the ex-wife said, well, that is what we meant, and then the trial judge's order doesn't side with your position, your client's position, but isn't there evidence to support what the judge did, regardless of the judge's final rationale?
I think that there's two questions there. The
Probably
first
more.
question,
I don't know. I don't even remember my question now, but go ahead.
the first question is, did the court, Judge Hare, hear parole evidence? The answer to that is yes, but the longer answer is it's more complex than that. The judge's ruling was based on the language within the agreement, the four corners, and the judge said it's clear that this is what the parties intended. Because it's interesting, at the hearing, Judge Hare said this agreement is confusing. Even I'm confused. There are missing terms here. And then after the hearing, the judge pivoted and said this agreement is plain as day. Mr. Palmer intended to divide non-marital assets.
But then don't we go back to some principle of appellate world here that says, okay, at the end of the day, I don't know if the applicant says this or whoever, that is the judge's ruling supportable by the evidence regardless of how she or he got there?
No.
No? And the
Tipsy
applicant didn't
Coachman
say
does-
that? I gotta stop saying applicant.
Tipsy Coachman would not apply here, Your Honor. Number one, the parole evidence is in favor of Mr. Palmer. If you look at the parties' financial affidavits that were filed at the very beginning of this dissolution action, the parties valued the pension, the fair market value, at $84,000.
But I mean, the ex-wife didn't say, you know, my ex-husband's right, that is what we meant, that I would just get my 40% of the 84? She didn't say that, did she?
That's what the dispute is, Your Honor, and then both parties
But you
disagree
said
about
that,
that.
I thought you just said that she kind of agreed with, she had a diametrically different view of your client's interpretation of the contract, and her testimony was different, wasn't it?
Yes, Your Honor.
So the trial judge heard saying, that's what we meant, I'm to get 40% of till the end of time, or till the end of till the end of our lives. And your client said, no, 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 no. It's a marital asset. We meant to divide that $84,000. And yeah, I didn't retire. I didn't go into drop because of these circumstances. What the judge accepted, and that was fine. It wasn't compelled to have to go into drop. But the judge says, well, I'm reading this contract to mean 40% of going forward. And that's consistent with the ex-wife's testimony, isn't it?
But the court's ruling was limited to the four corners of the agreement, was not based on any credibility determinations.
So if we sent it back and said, well, you know, you just based it on the four corners, could the judge says, okay, well, I did hear this, and I find the ex-wife's testimony to be more credible, and I believe that's what the agreement was intended to be, and therefore I rule the same way I ruled.
I don't think that outcome is certain.
No, I'm not saying it's certain, but it could be.
For remand with instructions that the trial court consider the parole evidence.
No, I get that. I'm not saying, then we wouldn't waste our time saying we're going to remand it and tell her that she won for a different reason. But what I'm saying is we remand it to say, okay, consider the testimony, the parole evidence, because that was your side's position all along, saying it's ambiguous. In fact, you said that's what the first judge said. It's ambiguous. Got to hear parole evidence.
Right.
But so he could go back and the trial judge could say, okay, I didn't do a good job writing that first time. I did hear the evidence. I can look at the transcript. This is my finding here. I find that the ex-wife's testimony is more credible as to the party's intent, and therefore I rule this way. And then at that point, coming back to us, let's say you all were the same lawyers coming back, we'd say, well, the judge did that, and the judge made a credibility determination, and isn't that the end of it?
I think the
How
argument.
would it not? I know you don't like where you think I'm leading.
I don't like that result.
I know you don't like where I'm leading you.
The-
And I'm not saying that should be the result, but that could be the result, right?
My answer to that would be that the testimony.
Sometimes okay to concede that and just hope for the best.
Right.
I mean,
That it's certainly within the province of the trial court to make credibility determinations based on the testimony, but I would say that that testimony has to be more than self-serving testimony. So Mr. Palmer is the only one that
both
offered.
sides at that point, though, counsel, would be self-serving testimony. Your client's testimony, understandably, your client's testimony would be self-serving, saying that's not what we meant in 2010. And she would say that's exactly what we meant in 2010, that I keep going. It's both self-serving, and that's what we ask trial judges to do, saying decide the self-serving testimony.
But there is other evidence from Mr. Palmer in the record to support the valuation of the pension in 2010 at 84.
I don't think anybody disputes that. I will give you, the value of the pension is $84,000. Your client's position is that's the number that we should go on. Ex-wife's position is, yes, that was the value back then, but that's not what we agreed to, that I would only get 40% of that portion of that. It was, I know this is sometimes a thing, and it happened a lot in trial courts too with me. It's like, I don't like where you're taking me, so I want to get off this train. But I mean, big picture, that is, 84 is the number. You say that's the end-all be-all number. They say, no, that isn't. That was what it was before, but that's not what we agreed to. Trial judge, decide.
Right.
Right. And the trial judge, and the trial judge didn't say, I'm not hearing parole evidence. Trial judge said, I'm going to listen to what you say, and I'm going to listen to what you say, and I'm going to rule. Now, the trial judge ruled based on four corners, as you're using that term. But I guess I'm trying to figure, what do we accomplish by sending it back to say, okay, is this what you really meant to do, or just, I know it would be to know. I get all that. We don't have to, I'm using up too much of your time anyways, but.
That's okay. Your Honor, I understand the point. I agree with you in concept. I think here that there is some important evidence that, well, first, if you reverse because it's not clear within the four corners, you should remand because the court should consider it under the appropriate standard, the parole evidence standard. And there is some other interesting distinctions in the evidence, whereas Ms. Suzanne Palmer signed the financial affidavit that listed the fire department pension with under marital fair market value, it says $84,000. In the non-marital column, I don't think that that's checked at all. So the court would need to weigh those things, which did not happen.
It had no value non-marital at the time they were getting divorced.
Correct.
What number is she going to put in?
Correct. Correct. Yes.
Okay, let me ask you, as to part two of this it intrigues me too. Setting aside the income deduction order, the monthly income deduction order, if you were simply dividing an asset, let's say for the sake of argument, he retired your client retired in 2010, they had an $84,000 value, and wife's getting 40 and he's getting 60, he's going to, he's moving on to wherever, and don't they use quadros, QDROs for the record here, to divide up those assets?
Not for equitable distribution.
Well, how would you divide up the asset?
I think that that's the struggle that the courts are having because of.
But okay, let's say that's the only asset. They don't own a home, they don't have any bank accounts, they're renting a house, and so it's, well, we're moving on our way, this is what we did or didn't acquire during our marriage, but we do have this because you worked as a firefighter. And he says, yes, I did, and it's a marital asset, we ought to divide it 50-50, and good luck ex-wife, good luck ex-husband, go our separate ways. So now they each get 42, using my math, using your numbers. Okay, how does she get her 42? How does he, he gets a 42 because it's not being alienated, he's entitled to it. But she's not, under the firefighter pension statute 175-241. Okay, how does she get that? What's the reality of, give me my 42 grand and you'll never see me again, God bless you, good luck, I appreciate our marital life, and until, I guess not till death do us part, but till divorce do we part. How does she get it?
Sure, and the case law touches on that and says there's other alternatives that the court could fashion, such as directing payment from Mr. Palmer, if that were the case here.
Give him the 42 and then he writes her a check. Give him the 84 and then he writes a check to her for 42? I'm just asking. I'm not, I know your defense, I'm not binding you to anything. I'm just kind of talking it out loud. How does this happen?
I think that there's a natural tension there on what happens, and that's the frustration with the appellate court, but the legislation says that you can't issue income deduction orders or the quadro for these types of equitable distribution.
Haven't trial judges, I'm trying to think back in my old family law days, I never drafted one because I don't have there were formed quadros that the agency or entity or the insurance company would say, here, for us to give the money away to somebody else, you need to sign this. And the lawyers would say, here, Lambert, sign this. And I said, all right, if that'll help everybody, that's great.
Right.
So in other words, it happens, but if I'm understanding this argument here is that can't happen.
That can't happen here, and that's...
I know, forget income deduction order being different from a quadro. But just like, if it was just, we're dividing it up and going our way, we're never going to have monthly payments.
Right.
You're saying there's no way to do it. He would have, walk me through this, and I'm not committing you to anything. He would have to get the money from the firefighters here, and then he would have to write her a $42,000 check to say, here's your half ex-wife, consistent with our agreement.
That's my understanding.
That's
Your
your
Honor.
understanding?
Yes.
No other way realistically other than that. And in fact, if he just says, I'm not writing you a check, you can't enforce it through contempt because it's not a support obligation, I guess you can sue me if you want and then try to collect against me. That seems to be the end walkthrough of what and I'm not saying it's wrong, that seems to be the end result of your position on issue 2.
There's a case that talks about what I'm saying with...
Yes or no?
I think that...
Say yes, that's really crazy what the legislature and the courts have done, but that seems to be where we got to go.
That's what the legislation is. I think that the failure to pay something might be enforceable by a contempt power.
Well, it's not enforceable. It's an equitable distribution. And the pragmatic part of me is saying, well, you get 42 and you get 42. Take your 42 and go. You take your 42 and you never have to see each other again, and good luck.
And there's a number of cases that have certified this issue as a matter of great public importance and asked the legislature to rewrite the law, and so far that has not happened.
And the Supreme Court and the IDOs have basically said, okay, the 61.1301 has impliedly, what do we call it, receded from the unalienability of these assets, but that's for support and alimony, which this is not.
Correct.
Ms. Murat, you're in your rebuttal time. Something you'd like to reserve?
I would like to reserve, yes, please.
Just be thinking about the question. My question was going to be, I don't want to take it up now, so this won't count towards your time, but what would be the relief then that you're seeking from us in light of the issue number 2?
In light of issue number 2?
Correct. Like what relief are you seeking, realizing quadro is not the appropriate remedy or the conduit?
The income deduction order is not the appropriate order here. And you want me to answer that now or wait until...
Later, you can.
Okay.
I will sit on the edge of my seat.
Okay. Thank you, Your Honors.
Good morning.
Good morning.
May it please the court?
Yes.
Attorney Annabelle Catania on behalf of appellee Suzanne Palmer, who is also in the courtroom, Your Honor. This case reminds me of buyer's remorse. Back in 2010, when these parties dissolved their marriage, they were amicable. These were not people fighting for a resolution, an end to their marriage. And when they ended their marriage, they entered into this marital settlement agreement, which clearly shows the intent of Mr. Palmer that Ms. Palmer was to get assets that accrued as of the date of his retirement. You see that in multiple ways. Number one, in the drop. There was an intention for him to enter drop. There's a paragraph in the MSA that says those funds that are supposed to accrue at that time, my client was supposed to get a portion of it and he would get the other portion of it. Drop doesn't occur. Drop doesn't exist until retirement. There is pure intent there. Mr. Palmer wanted my client to receive the asset as it's valued as of the date of the retirement. Otherwise, why give her any interest in
Drop's
drop?
irrelevant. In other words,
Right.
if the intent of the parties was, you're just going to get your portion of the marital asset, there's no point to talk about drop because he's not in drop, he's still working as a firefighter.
Exactly. And he wasn't even entitled to retirement at the time that the parties divorced. He only became entitled to his pension at 20 years of service. He wasn't there yet.
Wasn't vested at the time of the divorce?
He wasn't fully vested at the time. So there's another thing that the court should also consider when in this matter is if record of appeal, it starts on page 545. Let me make sure I've got that correct. I'm sorry. Yeah, starting on page 545. Back in October of 2024, so at the same time of this, that we're in this litigation on this motion for enforcement, the parties entered into a joint stipulation regarding the joint annuitant survivor beneficiary, a clarifying agreement. And this agreement also goes to show the intent that was in the MSA that at the time of my death, Mr. Palmer saying, at the time of my death, my ex-wife is going to get 50% of what is accruing at the time of my death. Again, that number would have been limited to what was at the time of filing of the dissolution of marriage if she was only entitled to get assets at the time of the dissolution. That is not what happened here. The only ambiguity that we find that I would agree with that was in the MSA states that he would enter drop up to 5 years. Like there was a time period. It doesn't expressly say what that time period is, but it said up to 5 years. It wasn't he had to be in there for a month, he had to be in there for 5 years. But that's like the only ambiguity was the length of time he had to be in the drop program, but it clearly stated that he was going to enter drop and that she would get a percentage of it. We don't believe that there is any ambiguity at all in the MSA otherwise.
Well, do you agree with, so the trial court did hear parole evidence about what the intent of the parties were.
Correct.
And it conflicted, and the ruling of the court is consistent with your client's view of the party's intent of the agreement. Do you agree with your opponent, though, that the trial court's written analysis is not, the trial court could have said, well, I've heard the evidence, I find that the party's intent was this, and I understand who wrote the agreement way back then, I think that's been overcome, this is what the intent is, therefore I find 40% of the benefits, even in retirement, past divorce.
So I don't agree that the court had to do that because the court said, look, if this issue had come before me, and it was on an original decision, my decision would not have necessarily been giving her 40% at retirement. He states this is what the parties contracted to. And I think without saying, hey, I've heard enough to say this was their intent, to me, the order implies it, and it says it in there. Look, the MSA is clear. It lays out the intent. If you look at all the parts, you can't just say, oh, she's going to get 40% of the pension without looking at the other language, which says at the time of retirement. And without considering why would he give her drop assets if he wasn't going to give her money after the time of retirement, at the time of retirement, or after the date of filing and the date of dissolution. There's also something that I want to address about the quadro. That was never addressed at the trial court level, and even though it was brought up. They never asked the court to fix that at that point. They never asked the court to rehear that portion and reissue that. They never challenged that at all at the trial court. But
is there evidence that, is it the firefighters union for Lake Mary, is there evidence in the record that they said, sure, give us an income deduction order and we'll honor it?
there is not evidence on the record because they never challenged it at the lower court, and that's why we tried to get it to this court. But they have.
Did you ask for an income deduction order and the judge put it in the judgment?
Yes. We asked for a quadro, and the judge put it in the judgment.
Is there a difference between, there's case law about, we're talking about the income deduction order. I mean, I use the example of the quadro because that's what I was familiar with.
It can be quadro or an income deduction, yes.
I don't know if those are interchangeable or not, or if they were interchangeable for the purpose of my questions. But, I mean, there is case law. I mean, there is an actual statute for firefighters' pension funds.
Correct.
175.241, and it seems to say, the benefits accruing, et cetera, under this chapter and this plan are hereby exempted from any state, county, or municipal tax and shall not be subject to execution or attachment or to any legal process whatsoever and shall be unassignable. Okay, then there's a Florida Supreme Court case, Alvarez versus Board of Trustees of the City Pension Fund for Firefighters, Police Officers of the City of Tampa. I don't know if you're familiar with it. It's at 580 Southern 2nd 151, and it talks about income deduction orders. Statutes mandating the entry of income deduction orders for court-ordered alimony and child support orders implicitly repeals the statute that would otherwise prohibit garnishment of a firefighter's pension benefits.
Yes, Your Honor.
So clearly we're talking about alimony or support owed to your client. That would be, it would be garnishable, deductible, and an
Correct.
IDO.
You're right.
But this is equitable distribution of assets, and there's post-Alvarez cases that talk about that's a different animal. The statute hasn't been changed. There's nothing that authorizes that. You can't do that, trial courts at all. And in fact, there's some later DCA cases that says even if you agree to it, you can't do that. I mean, case law where the husband says, sure, go ahead. And it goes up on appeal, and I think it's the second, Palmater or something says.
We don't deny that. I'm not denying that is what the law is. It's just, the issue is that it never was brought up so that the trial court could have corrected it prior to any of these proceedings going forward. But also, they never
Is there a motion
objected
for
to.
rehearing that was addressed to that?
They never did a motion for rehearing, is my point. And so the trial court could have fixed that at the trial level without it coming to this point, but the parties had agreed to it, and had we known that there was an objection, we would have had evidence. There was never an objection. There was never any
Evidence
discussion.
as to what?
That Lake Mary Fire Department saying, we'll accept it, and we'll do it this way.
Could Lake Mary firefighters change their mind? I mean,
I guess they could, but every communication, even up to the date of my answer brief, they were telling us, yes, we will do that.
well, I mean, if the statute says you can't do that you flat out can't, I mean, how's,
How I recognize that, reconcile that, Your Honor, is that the court could, under the laws of our state, the court wasn't supposed to order that.
well, I mean, how about if I say, okay, I'm in criminal court now, and you're in front of me in felony court, I'm sentencing you to whatever, you also have a misdemeanor that's punishable up to 1 year, and the defendant says, I like prison, I hate the Marion County Jail, please send me to prison for 2 years instead of the 1 year, and I'm happy to do it, and I'd love to do it, and I say, well, state, what do you think? And the state says, well, the goofball wants to go for 2 years, fine. And I say, all right, well, I know the statute says I can't do it, but I'm doing it.
Well, and that's
Wouldn't that become problematic on an appellate
Yes,
court
I
that somebody
agree.
actually then says, wait a minute, pal, you can't do that?
I agree, Your Honor.
Well, how's that? I mean, I know we're not talking about prison here.
No, but I agree with you.
We're talking about a statute that says, you trial judge can't enter this thing, whether that makes sense or not, and certainly there's been case law that says,
It doesn't really
as
make
I was
sense.
asking
Right.
your colleague over here saying, or opposing counsel saying, what happens here? Forget about the monthly payment. Let's say you were just dividing up the 84, and that was what
Right.
they agreed. We're moving to different parts of the country, and I want my 42, and we'll never see each other. We're amicably dividing. Good luck. God bless you. Have a good life. Whatever.
All that
But the quadro,
we're,
you can't
I
do it.
agree with you 100%, Your Honor.
I know that. Well, but we all can't make up our laws here because
Right.
Judge Wallace said so.
No.
So we can't make up anything. So under that scenario, if I understand your opponent, I think there's certainly merit based upon some of this case law, is what you're saying, is that you can't even enter an agreed upon quadro to do that. The pragmatic way of doing it would be to say, okay, give the guy, the pensionee, husband in this case, the 84, and he needs to write a check to the ex-wife for 42, and they can go on their way, which is wonderful in real, you know, in I don't want to say fairy tale land.
Right.
Because I've sat in a family law court before. But, okay, so now when he says, I'm not doing it because
Then we're back in
I'm
court.
going to Vegas and I met somebody else and, you know, you got plenty of money, ex-wife, and, oh, by the way, I never liked you in the first place. I'm not picking on her. I'm
No,
just
I
saying,
know.
Hypothetically.
And I agree with you. I
Well,
agree.
What happened? I mean, you can't
Well,
hold him in contempt because it's an.
Exactly, and so then it's a never-ending story of being back in court, and that's why when, in my answer brief, I said we recognize the law, however, it's a technicality, and so what is gonna have to happen is that the order has to state, you know, if we're just following the laws and we're not overlooking, and we overlook the fact that, hey, they never challenged it, and they never let the judge fix it prior to coming here, and the court has to then say, okay, well, he has to pay her the 40%. Now, because, something to clarify as well, because of this, what's on the record on appeal, that joint stipulation from October of 2024, which is on page 545 of the appeal, it's 545 and 546 of the appeal, they recalculated based on the annuitants now changing. You know, when you have because this pension is based on an annuity, and because my client is older than his now current wife, they've reevaluated the valuation on the amount of the pension, which is now the payments to Mr. Palmer have increased, which would mean my client's 40% should have been increased, as well as all the payments that he has received, which we just recently found out that because we were like, okay, here's this order, have you fixed your documents, and they reissued documents of what those numbers look like. I want to clarify, I'm not agreeing with you that the valuation is 84 and she's supposed to get 42. I don't want to, because,
I'm
okay.
using that
I'm
for
not-
number. I mean,
Yeah.
your position is whatever it was back then it had a value when they got divorced, but that really wasn't what they agreed to.
No, 'cause
So
the
I'm
document-
using-
yeah.
I'm using that number to make it, and I can divide
Absolutely.
84 by 2 easy.
Yeah, I just want to make
So-
sure, I've said a couple times I agreed with you, I just want to make sure I don't agree with you on that.
Not many people agree with me about anything, but in any event, so, I mean, if I'm understanding the argument here, and it seems like there's been case law that says, boy, this is just an odd thing, I wish somebody would fix it, i.e.
Right,
Tallahassee.
exactly.
But I mean, but they haven't yet, you
No.
agree? I mean, they could easily fix it by saying equitable distributions also can fall within 61.1301, but as we all know, that's for them to do and it's not for us to
Right,
do.
and we're behind
We
the
can
times.
suggest it, and they could say, yeah, thanks a lot, we got other fish to fry up in
Right.
Tallahassee, and do
Correct.
that. So, I mean, but that seems to be the scenario we have here.
Unfortunately.
As somewhat quasi-illogical, I don't want to be dismissive of the legislature. I mean, that seems an odd scenario when the parties agree and the equitable distribution statute envisions dividing up assets like these because we all have the same kind, we have assets like that in our job that we have, that there should be a way to do that, especially when the parties agree to a division of it. I mean, I know you disagree as to what
The
you
amount,
intend, but.
right, but-
You agree it's to be divided. It's just you don't agree
Absolutely.
how it should be divided.
Right, and that, to me, it allows for the play of Mr. Palmer saying, okay, I don't want to write this check anymore to Miss
Well,
Palmer.
I
And
understand. I mean,
then we're going to be
that's
back in court, so.
That's it's even more problematic. I'm not trying to tip off, you know.
No.
It's more problematic to say, well, you can't even put me, you know, like the last guy you're listening, he's looking at going perhaps to jail for not paying
Right.
out. He can't even look at that. It's simply your client's a creditor of his now.
Right,
And
exactly.
so, you know, no different than if the bank was suing him for money that they owed it, and you just say, well, there's no debtor prison, there's no anything. If he doesn't write a check, he doesn't write a check.
I agree.
It is what it is. And that doesn't seem to be consistent with what we want to do in family law world of not to try to get things to
Right.
be resolved amicably, which it was apparently, at least in 2010.
Right.
Here, but we are tied to what we have, and it seems your argument is, well, yeah, you can't do it, but nobody objected to it, so give it
Yeah,
give it a pass. I mean, we can use fancy,
Right.
we can use fancier legal terms here.
Right,
It's been
exactly.
waived or blah, blah, blah. But yeah, it's give it a pass.
Yeah, it was a
because-
waiver, and they never challenged it, and they never even challenged, they never allowed Judge Hur to correct it. at the trial level, and they never filed a motion for rehearing. They went right to a notice of
But he
appeal.
would correct it by what? By just simply
By-
saying, I can't put in the words, it's an
By
income
quadro,
deduction
you
order."
have to give her half, yeah, all he had, right, they could have given him the opportunity to correct it by doing a motion for rehearing and saying, hey, here's the case law on this, you can't do it by quadro. I know we didn't challenge it in the court when we were in front of you in trial court, but now we're giving you an opportunity to fix it, which is what the appellate rules envision, is like, look, if it's something that is
Oh,
administrative.
I wouldn't say ad nauseam, we're extremely aware of the motion for rehearing rule.
Right, so, sorry, I didn't mean to be
Ourselves, we have
disrespectful,
that
right.
discussion for frequently.
Right. So if they had done that, then Judge Hur would have had that opportunity. They didn't even address it at that.
What would he have done? I mean,
He could have done an addendum to the final judgment that says paragraph blah, and I don't have it off the top of my head.
Delete the reference to the IDO.
IDO and IWO, it needs to be paid by the 1st or 15th, whatever, day of the month, directly from Mr. Palmer to Ms. Palmer. That is not what we want, because,
I get
yeah,
it, but I mean,
but the judge should have been afforded the opportunity to correct it, and he wasn't. And there was no objection to it.
No, I mean,
So,
I
yeah.
certainly, we certainly have, we have a lot of discussions about those kind of arguments too, here. I mean, it's just, it's a strange scenario that there's a mechanism that seems pragmatically, and which is a dangerous word nowadays in the appellate world, there's a thing pragmatically to resolve this, but we seem to be statutorily precluded from doing that, or trial judges are. And so what do we do in light of the fact that the thing has only been brought to the attention for the first time to the appellate court, and we have principles of you got to make the argument to the trial court first? So what do we do with those scenarios here? And there's certainly chewable discussions that are had about that amongst appellate world people.
I agree. So if I could just address, I have 2 minutes left, but she brought up about, Florida law, and this is contract law, and, contracting, and he only used the four corners. Well, the four corners plus what the testimony was enough to show the intent. Again, I go back to the parties can contract, and there's lots of case law and progeny of it. And yes, I understand the Boyette case, but this case follows more of the line of, oh, I'm going to miss it off the top of my head. I think it was
We understand.
of Crawford and the progeny of cases of Crawford, where it's like, look, the parties can contract, and just because that's what.
I give my wife half, some of my mother's estate, even if it's a
Right.
non-marital asset, because I don't know, because I'm a good guy, or
Right,
stop
exactly.
hearing about it or something. I don't know.
Right. Are there any other questions from the panel? Then I'm going to ask to be excused. May I be seated? I have 59 seconds.
Oh, you don't want to hear the rest? I mean,
Yeah, I want to, yes, I
You can go if
will.
you want, but I assume you
No,
want to
I-
hear the rest on the other side, but.
Ms. Murat, you have about 4.5 minutes.
You remember Judge Wallace's pithy question?
I do, and I have a answer for you, Judge Wallace. First, I'd like to say that Mr. Palmer's interest was vested at the time of divorce.
I'm sorry?
That Mr. Palmer's pension benefit was vested at the time of the divorce, so that was an inaccurate statement, and that's supported by the record. So it vested after 5 years of service. But to answer Judge Wallace's question, the court, if it remands on the income deduction order only, it should leave it to the trial court to devise the remedy. And that's what this court's opinion in Board of Trustees of Orlando Police v. Langford says. Being a court of equity, the trial court is entitled to devise a remedy through other means to safeguard the former wife's interest in the pension.
We scratched our heads back then in 2002, didn't we?
It may be possible to construct a degree which requires payment of the pension funds to a trustee to be held in a joint account for the parties' joint benefit, and requires the trustee to distribute the funds when received to the party entitled to them, and that was in 2002.
And we agreed with the first DCA in Volante, I think, the 1994 opinion that basically said, they scratched their head too, but they said, hey, it's not been an implied revocation of that earlier statute. The 611301 did that for alimony and child support, but not equitable distribution.
Correct.
Might be a good idea for somebody to think about doing that, but until somebody does that in Tallahassee, not them in Tallahassee, the legislature in Tallahassee,
Right.
that's where we is.
I'd also like to let the court know that the Lake Mary ordinance for this pension is in the record. That's at record 408, and there is an unassignability provision in that ordinance for the pension. So in addition to the statutes that, Judge Lambert, you've been citing, there's also the ordinance that says that this pension is unassignable.
Which would be, in fact, that's a good point. I mean, if they actually had something that said it was assignable, then that would seem to be, we would be outside the statute because they contracted otherwise. But I mean, I don't want to dig too deep into that because that would be some other issue they'd have with Tallahassee, but.
Right. And
Okay.
briefly, I'd like to tell this court.
I mean, is there evidence about that they said, okay, we'll honor the IDO if you send it to us?
That's not in the record, Your Honor,
There's
no.
no evidence about it? Okay.
No.
Go ahead, sorry.
And even if there was, I would suggest that they ask their counsel to revisit that issue. But
ahead.
I'd like to tell the court why it doesn't need to reverse to go to parole evidence or why that doesn't matter. And that goes back to contractual interpretation in the four corners of this agreement. This court should say, what is, upon its de novo review, what is the purpose and intent of this agreement? And that's all over this agreement within the plain language. Section 8 is specific to assets acquired during the marriage. That's statutory language.
Why is there language in there about drop then?
Drop is statutory. In 61075, marital assets includes pension or a deferred compensation plan, which could include drop. The drop cases make clear that drop assets do acquire during the marriage because it's just deposited later. The benefits earned during the marriage and then deposited when drop starts. So just because there's a deferred distribution or that drop occurs in the future, that doesn't mean that it's non-marital. And that's what all of the cases say. The drop argument is a fallacy. The appellee's argument on drop is just wrong.
But your position is that $84,000 was the marital asset, and she would be entitled to her percentage of that 84, right?
Well, based on the high five calculation, so it's not just the 84 high five salary, there's a calculation that goes into it that an actuary testified to at a deposition. So yes, it equates to roughly like $1,400
But I
a
mean,
month.
her percentage, her 40% is of that 84, whether it's a monthly or whatever.
As of 2010, that was not the value in 2022 when Mr. Palmer retired.
But counsel, what about sub C2, where it's talking about or connected with the husband's employment or military service, past, present, and future, except as otherwise specifically provided herein? So if the drop argument is a fallacy, if we have that, we're talking about the husband's death until all
But
of...
you have to look at, I'm sorry.
go
Ron.
ahead.
At the beginning of C, it says, as part of the equitable distribution of the assets acquired during the marriage. So subsection 2 is talking about assets acquired during the marriage, the drop or the pension acquired during the marriage. So you go back to the rules of contractual interpretation. You have to construe this agreement as a whole. Defined terms should guide the court's interpretation of undefined terms. And there's good discussions of that in the City of Homestead v. Johnson case that's cited in the briefs. It says, we rely on the rule of construction requiring courts to read provisions of contract harmoniously. Undefined terms must be viewed in relation to the other specified terms, I'm paraphrasing, and provisions contained within the agreement. And an agreement must be interpreted with its stated purpose. Again, in the last part, or in Section 5, the MSA expressly says that the parties keep their separate property, period. There is no exception. And at the end of the agreement, it's Section 18, the parties specifically acknowledge that the marriage of the parties was long-term, and as such, spousal support may have been awarded. The parties specifically acknowledge that the distribution of the marital assets and debts that is stated herein is in lieu of spousal support. So if you back out and you look at this agreement as a whole, the purpose is to divide marital assets, nothing more.
Counsel, your time has expired.
Thank you, Your Honor.
Thank you. This case was well argued. Thank you for your arguments, and we are adjourned.
Start keeping track of this.